Look versus funcionalidad. Tendencias en la protección del diseño industrial. Panelistas: Adam Giorgi, SBGK, Hungría. Renata Righetti, Asipi Buñón, SPA, Italia. Richard Stockton, Banner Witkoff, Estados Unidos. Moderador: Iván Sempere, Padima, España.
Bueno, bienvenidos al último panel de la mañana, denominado Look versus Funcionalidad, Tendencias en la Protección del Diseño Industrial. El panel lo va a moderar Iván Sempere, de la firma Padima de España. Iván es socio y director legal de Padima, doctor en Derecho Mercantil y profesor honorífico de Derecho Mercantil de la Universidad de Alicante, de la que es miembro de su Consejo Social, con una amplia trayectoria como abogado, mediador, perito judicial especializado en propiedad intelectual, concretamente en diseño industrial. Iván es miembro activo del Comité de Diseño de la International Trademark Association, INTA, donde preside el Comité de Law and Practice para este periodo. Es coordinador del Grupo de Propiedad Industrial e Innovación de la Asociación Nacional de Defensa de la Marca, ANDEMA, así como consejero en diversas instituciones y organizaciones nacionales y multinacionales. Iván, adelante.
Bueno, muchas gracias. Es un placer poder coordinar esta mesa. And, well, you will agree that IP is, generally speaking, to protect innovation. Functional innovation is worldwide protected by patents, and in some jurisdictions also we have utility models. However, to reach these exclusive rights, certain protection requirements have to be met. And definitely those are different from the existing ones when we claim for a trademark or when we claim for a design. In short, we could say that if you want to protect a technical feature, you must apply for a patent, not for a trademark, not for a design. Last week, European Court of Justice decision refusing trademark protection for the Rubik Cube is a good example. But taking the issue under the design umbrella, functionality clause may affect to validity and also to the scope of protection of a design. You will agree that most of, or the vast majority of designs we can find incorporate both ornamental and functional features. So, generally speaking, again, because this is something that will be analyzed in the panel by my colleagues, generally speaking, if a design have all features technical, this design could be declared invalid. So validity is one ground, and the other ground is scope of protection, as the question is, what happens with these functional features if they can or can't have an influence in drawing the overall impression of a design. So we have these two grounds, and the panel will be structured following these two issues. First, validity, and secondly, we will dive into the infringement scenario. For doing so, I have the great pleasure to introduce Renata, Richard, and Adam. Well, all of them well known because of their academic contribution or because of her frequent presence in different IP forums. But it is necessary to underline that Renata is president of her IP firm in Italy, Bourgnon, and also is the president of the IPPI International. Adam is a junior partner at SBGK. Did I say it correctly, Adam? Yeah, SBGK IP firm. And he has a great experience in design protection. And finally, Richard is the principal shareholder at Barnett & Whitford, Chicago. And he also has a great experience in drawing international design, prosecution, and enforcement strategies. So thank you very much, you all. I must say that among all cards I collected in this nice event, I have one yellow one, which is from our colleague Ivo, which is the president of the Indecopy. I will use it just to catch your attention or to get your attention when 2 minutes of your time is left. And I had a red one of nice colleagues of Bolivia, Escobar and Escobar, and I will raise that one when you are running out of time, okay? So many thanks for accepting this invitation, and now, Richard, the floor is yours. Thank you.
Thank you all very much. It is a great pleasure to be here at Asipi. This is my first time. I've thoroughly enjoyed it. I love the program, I love the receptions, and most of all, I love the people that I have met here. Peru has been very welcoming. It's my second time here. I feel very experienced now because I now know the difference between a llama and an alpaca. I have learned that. So now I bring my children back and I will show them my knowledge. Today we're going to talk about functionality, first from the US perspective. Functionality is a two-headed monster or animal, depending on who you talk to in the United States. There's functionality based as a ground for invalidity of a design. And then there is functionality that is assessed in the context of determining whether a design is infringed by another's article. This is the base statute in the United States. It's 35 U.S.C. 171, and this is the raw requirements to get an industrial design in the United States. Whoever invents any new, original, and ornamental design for an article of manufacture may get a design patent. New and original are things we're not going to talk about today. Those are the classic novelty questions of patents. That form a cornerstone of the law in the United States. And I should add that in the United States, the design law is meshed in with utility patent law. It is called a design patent, and it is considered almost a cousin of a utility patent. So that's different than some of the other jurisdictions. There are a few things we know about designs that have been established since the Design Act first came into play back in the 1840s, 170 years ago. The first is, again, this is a threshold requirement. So if a design is not ornamental, then it is invalid. So you can try to get the design through the design office to procure the right. Rarely in this day and age will the design office, the United States Patent and Trademark Office, reject a design on the ground that it is not ornamental. But this then gets to the question, what does ornamental mean? And the closest thing we have as to what ornamental means is that ornamental means if the appearance is not dictated by function. This came in a United States Supreme Court opinion until the Apple-Samsung opinion, which you may be familiar with. This was the closest a design patent ever got to the United States Supreme Court. The case was Bonito Boats v. Thundercraft Boats. The problem is that this case was not about a design patent. It was about a special state law protection, sui generis protection of a boat hull. But they did say in there that ornamental means not dictated by function. We also know one other thing, and that's ugly does not mean dictated by function, and thus not ornamental. So just because a design is not pretty does not mean it is not ornamental. This gets us to the point where the courts begin to diverge. To me, it is clear what the courts are getting to, but there is a lot of different case law in the United States, and this is where the argument comes. We have to look at the context of function. I have two cases I would like to share with you about the context of function. Actually, three. The first is Hupp. This is from 1997 from the Court of Second Instance in the United States for patents, including designs. All of our appeals in patent matters, including designs, go to this court, and its decisions are supposed to be binding. Here, you can see the design was a mold for a floor, and it was argued at the first instance level that the article performed the function of molding a floor, and therefore the design was invalid. The problem there was that the court, in the first instance, confused the fact that the function of the article itself, they confused that with the function of the design. Maybe put a better way, there are many different ways to mold a floor. You could have squares, you could have circles, you could have the Inca cross. There are numerous ways that you could do that. And because the design itself was not functional, it was chosen as an arbitrary design, so too the design patent was not found invalid for functionality. Now it gets a little more complicated. This is a shoe case from 1993, LA Gear. And here in this case, it was argued that different components of the design, so the entire design was the shoe. That was the claimed design. It was coextensive with the article that goes on it. And it was argued in this case that the portions of the design were functional, and therefore the entire thing was functional. So let's break this out as they argued it. This V-shaped piece provides foot support and reinforces the eyelets on the shoe, the holes. This piece provides shoe and foot support in the most important part, in the middle of the foot, underneath. This side protected the Achilles tendon and reinforced the rear of the shoe. That's not right. You cannot take all of these things. The defendant tried to say, so you take all of these things together and now they are, the entire thing is dictated by function. That is not correct. The way you must look at it under United States law is to say, and this is a quote from the court, in assessing functionality, the ultimate question is not the functional or decorative aspect of each feature, but the overall appearance. So you have to look at the overall appearance. And this makes sense because any article of manufacture has a function. I challenge anyone in here to find an article of manufacture that does not have a function. And any article of manufacture divided infinitesimally, so down to the minutest level, has a function. Each one of those components has a function. So this is a big battle in the courts that you often see. So functionality in the United States for invalidity it's a very hard doctrine to establish that something is dictated by function. A good example of this is the Apple-Samsung case again. So the final judgment was $399 million for the infringement. In that case, there were trade dress claims and design patent claims. The trade dress claims went down on functionality grounds. In other words, the doctrine there is much stronger to invalidate trade dress based on function. And part of that is because trade dress in the United States can continue on forever as long as you continue to use it. but the design patent survived. This case that we're looking at now, Best Lock, this is the only case in the United States by the Court of Second Instance that has ever found a design patent invalid for functionality. It's a key blank. And you can imagine what was happening here. The designers thought we will get design patent protection, and then that will help make our locks more secure because people will not be able to duplicate the key without infringing. The problem with this case is that the only thing that was claimed was the actual key blank itself. And the court, in that case, imported in the actual lock. They imagined the lock, or they drew from the record to establish the lock, and they said that because this key blank could only perform the purpose of fitting into this particular lock, that it was functional. It was dictated by function because its only function could be to go in the lock. In the United States, appellate courts have 3 judges. This was a 2-1 decision. It is highly controversial. Just recently, in fact, there was an auto parts case, ABPA, which limited this case a little bit. So now functionality as a doctrine for invalidating a design patent has become even more difficult in the United States. So now we'll have the European perspective.
Hello, good morning, everyone. Thank you for Asipi for inviting me for this event. I'm happy to share my views on European design law. And thanks, Ivan, for introducing the panel by the reference on the Rubik's Cube case. It's one of a case which our firm is handling, so I'm not able to comment on that right now. Most likely it will be appealed to the Court of Justice of the European Union. But anyhow, yeah, it's a good way to compare European Union trademark law and design law, but you have to be careful when you do that because the object of protection is different in case of trademarks and designs. In trademarks, you know, we protect source of origin, while in the design law, we protect the appearance of a product. As far as the legal background, the Paris Union Convention and the TRIPS provides us some foundations, but for us in the European Union, it's the Community Design Regulation, which is a sui generis protection in the European Union, which means that all countries, all member states have to follow the rules of this regulation. The regulation contains recitals which apply for our topic, and it says that technological innovation should not be hampered by granting designs to features dictated solely by function, but this doesn't mean that aesthetic quality have to be met. Also, it says that features should be excluded from protection, which are obviously dictated by function. Our core legislation is Article 8.1, which says community design shall not subsist in features of appearance of a product which are solely dictated by function, its technical function. This, as our colleagues was saying, definition is pretty vague, and in the European Union we had diverging case law in all of countries. Therefore, 2 different approaches were established. The first is the mandatory approach, aka the multiplicity forms test, which is actually where the question has to be asked. It's are there any alternatives to the same function? So can you show another design fulfilling the same function but has a different appearance? Well, this test had a criticism that it would only apply to very few cases. It's a very strict approach that it hardly will result in invalidating any designs. Obviously, right holders were in favor of this approach because they were keen to protect a broad scale of designs and obviously enforce them towards infringers. Well, on the contrary, in other countries like the United Kingdom, the causative approach was developed, which is also known the non-aesthetic considerations test. This has also some flaws. that it's not so transparent, and the cross-examination of designers is not really possible, that it would only apply for cases where it's attributable to the and caused by the function and how the designer actually developed its design. Here, the test is to ask what went on in the designer's head while this design was developed. So these two approaches were fighting against each other, and within this battle, the European Union and IP Office, before the OHIM, developed its own new approach in this chef cutter case. As you can see on the screen, it's a shredder machine where you can put in paper or other materials to destroy. The European office sided with the causative approach, saying that this design is solely dictated by the function, because that was the only relevant factor when the feature in question was selected. Now, coming to this diverging case law, and also from the European Union, there was a case recently decided by the Court of Justice of the European Union, which is the highest court in the EU, based on a preliminary reference, which is a reference made by a national court in case of infringement or counterclaim for invalidity. In this case, Dosaram GmbH is the owner of centering pins, as you can see on the screen, which is used for welding machines. And Keramtech is also a manufacturer of similar products of centering pins. Now, the plaintiff filed action in Germany, and on the second instance, the defendant filed a counterclaim for invalidity, and the second instance court stayed the proceeding and sent two questions to the Court of Justice to answer. The one was about which approach we should follow. Is it the mandatory approach, or is it the causative approach? And the second question was about which hypothetical person we have to use when we assess functionality. As you may know, that in European design law, it's the informed user who is the relevant person assessing the scope of protection or validity, which is not a technical person, not an expert like in patent law, but it's also not the average consumer, which is not familiar with designs. Therefore, this new person was asked whether it has to be used during this assessment. Well, it has to be said that we must differentiate between aesthetic quality and merit, which is not required by the European legislation, and aesthetic considerations. In terms of the first question, the court said that it's very important that the European legislation is providing protection for visual aspects of a design. So the parts which appear on the outer, which is kind of appealing to the informed user. This was also confirmed by a previous decision of the Court of Justice in the easy sanitary solutions, and also comes from the definitions of the design in the regulation, that it has to, the appearance, the outer visual aspects matter the most. Secondly, the court also said that we have to look at the objectives of the regulation, and as said in the beginning, the recital 10 says that, well, technological innovation should not be hampered by granting designs for those features which are dictated by technical function, meaning that the legislation and the court wants to channel innovation towards patent law, while leave design law for those where visual aspects play role. And as you can see on the screen, the court sided with the aesthetic considerations test, saying that where considerations other than the need for the product to fulfill its technical function, in particular those related to visual aspects, have not played any role in choice of those features, even if other designs fulfill the same function exists. The last part says that, well, design alternatives do not matter. And this is kind of similar to the decisions in trademark law in the Phillips-Remington case or the Lego case and now the Rubik's Cube case. So it seems that the Court of Justice tries to align similar ways to assess functionality in terms of designs and trademarks, which I believe they might not be true or correct, but so far this is what we have to deal with. And as with regards to the second question, it was asked, who's this person? Is this the objective observer? Well, the court said that there's no reference to this hypothetical person in the regulation, so we cannot create a new one. It has to be the court or it has to be the office which examines functionality and has to be made in an objective manner. It has to be looked at first of all design, see what kind of information is about the designer's motivation, and also maybe to see about the use of the design, some evidence. With regards to the last part of how the design is used, I'm not sure if that is a correct way to assess anything, because use is not a requirement in design law, and the scope of protection and invalidity is always dependent on the priority date and not on any kind of use. So there's no reputation in design law, there's no generic terms in design law. So it has to be said that design law is static, it is set for the date of the priority. So to conclude, the European Court is now finished a long debate, and it has to be seen how national courts really apply these situations. In Hungary, our courts have been applying already EU-IPO case law. Actually, they referred to that already, so it's not going to be a lot of change. But in terms of Germany, where they applied the multiplicity forms test, they will have to adapt to this situation. And this has to be also adapt in design strategy of filings, not just in terms of enforcement, because previous designs which were filed, they also can be invalidated retrospectively. Therefore, I would say that filing designs have to be really assessed, and there should be at least some part, one essential feature which is not dictated by the function. It gives a visual, ornamental, as the US colleague says, aspect to that. So briefly, that was about the functionality test in terms of validity, and we will turn towards the scope of protection. Thank you.
Okay, now we will jump into the scope of protection scenario with the European perspective first. Renata, thank you.
Good afternoon, everyone. Very briefly, actually. I wish to start mentioning that I'm here, and so I have to promote a little bit the work of my association, which is AIPPI, as you know. So I wish to start my presentation reminding you that the last time that AIPPI discussed design was on the occasion of the Congress in Milano in 2016. You know, the main goal of AIPPI is try to harmonize laws and practices on IP matters. And design, as you know, is one of the more controversial and different part of the IP rights. Different approach. For some jurisdictions, they are just part of patents world. For others, they are a third entity together with trademark and patent. So a very different approach. So in the effort to help to harmonize the law, there was a long discussion, very, very strong. And Ivan was one of the persons in charge of this discussion, and he remembers very well how difficult it was to reach an agreement at the end of a very controversial discussion. At the end of the day, the final statement of this resolution was that no visual portion of the appearance of the product should be excluded from consideration, which is to say that everything compose the shape of the design itself. And even if, of course, the functional characteristic cannot be protected per se, all the visual aspects of such portion should be taken into account, which is to say the general features of the whole object must be taken into consideration. 2 years later, we discussed a partial design issue, and it took place actually in Cancun last year. And at the end of the day, the discussion was definitely easier because the conclusion of the Milan decisions were kept. And the only thing is that in the assessment of the overall impression created by a prior design and the casual product in the case of infringement, the surrounding context need not to be excluded. So also the part of the design which is dictated by the functionality. Further all this discussion, there was a big effort to put together informations on different jurisdictions, and it was published a book in which 25 jurisdictions, as far as functionality and designs are concerned, are taken into consideration and explained. Talking about enforcement, it's important to remember that in many states within the European Union, there wasn't actually any decision taken yet by any court of any level of court on the matter of functionality and design protection. Guidelines of the European IP Office mention once again that when an object is in the shape of an object constituted only by its functionality, it cannot be protected as a design in any way. According to obviously the Article 81. I want to mention that the two examples that you see here are the most famous, and they are always shown as an example of a only functional shape. To be precise, I put the shapes here just to give an idea, but the last version of the guidelines published these days on the website of the UIPO do not represent again the figures which the images that were comprised in the previous version. Discussing about the consequences of the Doseram decisions, which is perceived as the final word said on this subject matter for the time being from the European Court of Justice, we have to take into account that it took place in March last year. And it means that only very few national courts had the opportunity to to refer to such a decision when discussing specific case. I try to collect several cases, but actually there are very few. So I just selected a couple of them. One, and both of them that I will mention are mentioning Doseram, even if there is nothing very new in the decision itself. The first one is a decision taken by the Court of Appeal in Frankfurt. And this is a very simple case in a way, and even before Doseram probably, it will have the same results, because we are talking about the shape of a medical device. And if you look at the image, the one on the left side, it's almost completely the design, the drawings of a corresponding patent application. So the entire shape of this object is purely functional, and therefore it was maintained that it wasn't valid as a design. The other case I want to report to you, quite a famous one actually, was decided upon by the Tribunal of Grande Instance de Paris. It's by July last year. In this case, there was an infringement procedure started by the owner of the design, and of course the request of invalidity of the design mentioned by the defendant. And the judge in this case stated that it is true that some parts of this design have a functional functions. For example, the second on the right, where you can see how the thing is closed because it's a comfortable thing and the air has to go inside, and the air must be kept inside the object. And therefore, the judge mentioned that yes, this is functional. He has to keep the air inside, but there are many other different ways in which the air can be kept there. So the way in which it has been chosen is to give a special appearance to the object itself, and therefore the defendant was denied the recognition of the invalidity of this design. Very simple. I'm sorry, I don't have any other cases to report as yet. Maybe in the future.
Okay, many thanks. Many thanks, Renata. And now is your turn, Richard, with the US perspective. Thank you.
Hello again. So now we're going to look at the US perspective on functionality for scope. So this is different, again, than invalidity. The invalidity context is, should the design have been issued in the first place? Now we are looking at when you are assessing infringement in the United States, how do you handle functional features? Believe it or not, but this is actually the most common way an infringer attacks a design patent in the United States. The rule for novelty in the United States is so stringent, you have to have almost the exact item in order to invalidate, that it is very tough for infringers to find invalidating prior art to take out the design patent. Even in an inventive step context, what we call obviousness in the United States, it is very, very difficult to invalidate because the underlying, the first piece that you have that you then add the other references to combine has to be, quote, basically the same, unquote, as the actual design that is there. So let's look at this. I feel bad because the two cases that I talk most about, the Best Lock case with the key, and then the Richardson case, which I am about to talk about, are my least favorite design opinions by the Court of Second Instance in the United States. But I spend the most time on them because I think they show the most problems with the doctrine. So there isn't, in the United States, it just says in the statute, anyone who makes, uses, sells, or offers to sell the patented invention infringes. This is the same standard as a utility patent. There's nothing in the actual statutes in the United States that say exactly how you are to read that. In 1871, about 25 years after the first design law came into effect in the United States. There was the Gorham case. You have probably heard of that. Gorham v. White. It involves silverware. It is the same as today. Gorham made a full silver, completely sterling silver fork and knife set. And then the infringer, Mr. White, came around and had a cheaper silver-plated imitation. The case went to the Supreme Court, and with the exception of one other case in the 19th century, the next time that design patents got to the Supreme Court of the United States was Apple v. Samsung in 2016. What did Gorham say? Gorham laid out the test for infringement in the United States. What is that test? The test is if, in the eye of an ordinary observer, giving such attention as a purchaser usually gives, if that purchaser is deceived into buying one, believing it to be the other, then it is infringed. What's interesting about this test, there's three components to it. One is that it's an ordinary observer giving normal attention, so it's just an average purchaser. The next part of that that's interesting is its substantial similarity. That is the test. This is interesting because that's the same test for copyright, for example, in the United States. The other interesting part is the third component, which says the purchaser is deceived into purchasing one, believing it to be the other. That's a passing off concept that we have in our unfair competition laws in the United States and overseas. But that part is largely forgotten about that test, even though it's in the Supreme Court jurisprudence in the United States. People don't normally think about that. They think about the ordinary observer, and they think about substantial similarity. We got all the way to 2008, and there was a case called Egyptian Goddess in the United States. It involved nail buffers, and in that case, they slightly modified the Gorham test. They said now the ordinary observer is no longer so ordinary. They now have knowledge of the prior art. So you'll see why this is important in a second. I just want to give you the context of the case to understand it. What is interesting about that as well is that the court that modified the Supreme Court was the Patent Court, which is actually beneath it. So you can argue, if you are being cynical, that they had no right to do that because the Patent Court cannot overrule the United States Supreme Court. But that's where we are with the law. So going back, based on Gorham, this case came out. This is called Odds On v. Just Toys. It involves an American football with some fins on the end. You just saw it there. And this is the case that said what we're going to do for infringement, we're going to use the Gorham test, and we need to do two things. The first is we need to make a legal construction of the design. So just having the picture up there isn't necessarily enough. You have to have a court make a legal determination of the exact scope of the design. And this is how we're going to deal with functionality. The court in this case, the Federal Circuit, the Court of Second Instance for Patents in the United States, said where a design contains both functional and non-functional elements, the scope of the claim must be construed. In other words, the judge makes the legal determination first in order to identify the non-functional aspects of the design shown in the patent. Conceivably from there, the court could give the instruction to the fact finder, which can be a judge in the United States. It could be a jury as well. And the jury will be told, you need to ignore certain parts, or you need to factor those out, or you need to look at them in a certain way, and then assess whether the two designs are substantially similar. This is the actual claim construction on the right. So this was how the judge said you are to look at the design patent. And I should note that in the United States, they do say a picture is worth 1,000 words. But in this case as well, they feel that they also have to add the words in assessing similarity. On the top is the design, the claim design. You can see it's for the American football with the fins attached. And on the right, if you read the construction, what they are trying to do is identify non-functional aspects of the design. So they are talking about how the fins have gentle curves upward. In the eyes of the court, that was not seen as functional. They talk about how the front of the fins go all the way into the football. But this really affects the infringement analysis. There are a lot of people in the United States that would look at these and would find infringement between the two of these. However, for example, if you look where it says at the very bottom, the last two lines, so the fins seemingly protrude from the inside of the football. That is now a legal requirement of the claimed design. And because the alleged infringement on the bottom did not have fins going into the actual football, there could be no infringement as a matter of law. I would submit this is incorrect, and there is much controversy about this, and it is the way that the judge perhaps could control how the jury's outcome could come about. With this context in mind, we get to the Richardson case, my other least favorite case in the United States. This involved a claim design, which is on the left at the bottom. It is a multi-tool. It has a hammer, it has a crowbar, it is used as a carpentry tool to build houses. On the right is Stanley Works' accused FUBAR product. FUBAR, I'll omit the first word, but it's a well-known expression in the United States for messed up beyond all recognition, and they call it, the acronym is FUBAR. So Richardson was a smaller inventor. He sued Stanley, which is a major tool manufacturer, and in the court's opinion, they were not very clear about what you do with function. So when Renata talked about the AIPPI resolution that we had in Milano, she noted that no visual aspects should be, quote unquote, excluded, but less weight can be given to functional aspects. The problem with this opinion is that the Federal Circuit could not make up its mind about what to do with functional features. In one part of the opinion, they said you should discount them. In another part of the opinion, they said you should factor out the functional aspects. And in yet another part of the opinion, they said you should completely ignore them. How do we handle this? This caused great trouble with the courts in the United States. It still causes trouble. But now we need to figure out what are we supposed to do with functional aspects in the context of scope. Let's have some ideas. So if you discount, based on the English meaning of that word, perhaps what you do is you look at the pieces that are functional and you still keep them in the back of your head. That's what I mean by the gray area here. You still keep them around, but you're really focused on the part that really isn't functional. And of course, you could argue that the piece that's still in black here, it's functional too. It's the way that you grab this particular article. So this is a very subjective battle that occurs. What about factoring out? So here's the way we could do it with factoring out. We can just say, let's find all the pieces that are functional and completely exclude them. You can look at maybe the Community Design Regulation 881 and say these are features and they should be, the features should be taken out. You know, they should be, these features should be excluded. Or you could just ignore them. Pretend they're not even there. Now this seems a little silly. We're going to take a design that issued that was for the entire article. It was in solid lines. And now we're just going to say that the only thing you really should be looking at is this little hunk of metal in the middle. The funny part about this is it gets even more absurd than this. In a case called Ethicon, which I do think was very well written, the court of the first instance, it had to do with a tissue sealer. The court of the first instance in that case looked at a design patent, took out the functional features, and said the design has no scope. So there's nothing claimed at all, and therefore it must be invalid. Well, that seems rather silly that someone would go to the United States Patent Office, they would get a design, they would claim the design, the US Patent Office would search it because we examine for prior art, they search it, they look for things that look like it, they grant the patent, and then it goes to be enforced, and the judge says, well, I know you got a patent, but actually there's nothing there on the paper. It's just the same as having a blank sheet of paper. You have to give our courts a break, though, and the reason why is that patent law cases are less than 1% of the caseload in the United States. Some judges like them, but most judges hate them. They are long, they are expensive, they are drawn out. So you already have patent cases being very, very difficult for many judges. Now you have design patents. Of those 1% of cases that are utility patents, only 1% of those are design cases. So you have courts that really, in many judges' careers, even if they've been on the bench for 15 or 20 years, they haven't seen a design patent case. They have no idea how to assess the rules and how to construe it. And that's why you get a court of first instance essentially reading a design patent to say that there's nothing on the piece of paper. It's a tough area of the law. What is the proper way to do this? And this brings us all the way back to the Egyptian goddess case and to Gorham. I would submit, and where I think the courts are going with this, is that you are asked now as part of the Egyptian goddess part of the US design infringement test, you are asked to review infringement in view of the prior art. So this patent was issued in the late 2000s. The little bubble on the right, that particular multi-tool, that's from 1927. So it anticipates, or it would render obvious if it was identical, the claim design by almost 80 years. What I would submit the proper way to assess functionality for scope in the United States is to keep in mind the prior art and ask the fact finder to make the determination of whether the similarity, the substantial similarity between the claim design and the Stanley Fubar in this case, which is on the left, is that similarity because of technical function? Perhaps it is when you look at the, like you look at the back of the hammer and the fact that there's a slit in there which is used to pull nails up. So maybe the fact finder could make the determination that that's a functional aspect that isn't worth assessing in the infringement analysis. At the end, I would submit as well that bad facts make bad law. In the Richardson case here, there are many people in the United States who are very experienced with designs who say this case should never have been brought in. The problem is then it made it and they appealed it and now it is binding law for everyone. Design patents are often received in the United States. They're often obtained because they're cheaper than utility patents. And the clients who get them often are under the mistaken understanding that the patent they are getting protects the underlying utilitarian aspects. I think that's exactly what happened in this case, and unfortunately the rest of the United States has had to dig out of this particular case for almost 10 years now. We have a very good judiciary. They are doing a nice job with it. They have some cases that I think have gotten more back on track, such as the Ethicon case I mentioned, but this has been a very, very difficult concept for us. Thank you.
Okay, thank you, Richard. Thank you all. I think you made a great job summarizing both views, EU and US. And now for discussion, I suggest to do something practical, and let's talk about real things. So, would you, how is it? Yeah, that one, okay. Let's talk about that device. Okay. This is an open discussion also with you, the audience, but I will first like to ask the panel, what's your opinion in terms of validity? Just imagine this is a registered design. Of course, I totally agree with you, Richard, that for the assessment on functionality, we should not consider isolated the functional provision. We should keep in mind the state of the art, and in our case also the freedom of the designer, okay, to design. But having all this in mind, would you consider this device is valid or not?
Well, honestly, if a client of mine will ever come and ask, do you want me to file an application for the design, I'd say, don't be kidding. Why? Because actually, this is functional, but we know it doesn't matter. Almost a lot of objects or products are functional. They have a function, a lot of things they have. But this one, in my view, doesn't have anything which is different from the pure functionality of the object. Of course, we can imagine 3 holes instead of 2 or something else. But at the end of the day, I cannot see anything which is not functional in this object.
I agree with you, Renata. So this one, I would say that it's purely functional, since all the essential features like the 4 holes are there to fix it to a wood door, I guess, and the middle part is all the lines crossing. They show that it can move. So those features are in order to open the door, and to be a square is also a feature here, but the square also supports that it doesn't fall off, and it has a strong fixation to the door. So if you think all these parts together, it's invalid, yeah.
I am a strong proponent of design patents, as you may have noticed, but even here, assuming this was a novel design, I think it is very difficult, even looking as a whole versus as particular components, to argue that this design is not dictated by function. I would offer a couple of thoughts about it that maybe will color the discussion going forward as well. Which is, in the United States, we have had various tests proposed to establish whether something is dictated by function. The latest round has said there is no particular test that needs to happen, but that the availability of alternative designs is important, if not, quote, decisive, unquote. Compare and contrast that with the Dasaram decision that we just talked about, where the existence of alternatives is not decisive. So we have a clear contrast in the law. Going beyond the existence of alternative designs, there are some other factors as well. But here I think you can almost stop there, because it's very difficult to look at this and say, how else could you do it? Perhaps you could have 3 circles cut out instead of 2. But in that situation, you would then go to some of the other factors that United States courts have established in the PHG case and Barry Sterling. Some of those to think about include, number 1, is this the best design? Number 2, would the alternatives have reduced utility and practical usage, practical technical function? Number 3, whether there are utility patents on this particular item. Because again, if we're assuming it's novel, perhaps there are utility patents talking about the benefits. Number 4, advertising, touting the advantages of this particular design from a technical function perspective. And number 5, are there elements not dictated by function? Looking at these particular factors, I don't see how any of these weigh strongly toward having this article or this design not be invalid as being dictated by function.
Great analysis, Richard. Thank you. Any different opinions from the audience? Come on, we need Latin position. Here's Europe, US. No different opinion? Okay. This is a very simple one, so let's switch into the next one. Okay.
He's making this very difficult for me.
Yeah. It's minimalism. Okay, feel free. Go ahead. You go ahead.
Oh, please.
I would say that this is not functional per se. So I can see a lot of glass, like for this one just in front of me, which is also glass. It holds water, but has different shape. And you have to take into account that already minimal differences between designs make them novel, at least in Europe. And I would say, in this sense, there's no functional feature, actually, in technically functional feature here, unless you consider drinking water is technical.
I share your opinion, Adam, because actually a glass is functional per se. We use it just to drink water or any other liquid, so it's functional per se. But the shape, let alone novelty or originality, new shape of the object per se, can be at least perceived as creative in a way, original, because it's not necessary to have such a shape just to be able to drink water. So we can discuss a lot about the originality of this thing, and probably it cannot be registered because there are so many other shapes very, very similar, but keep in mind that nowadays the differences among shapes are taken very much in account. And just to mention one thing which impressed me a lot, there was a very recent decision last September issued by the General Court of the European Union in a case in which it was discussed against a supposed to be infringer of the shape of the famous Vespa, one of the different models of Vespa. And the General Court of the European Union stated that the differences which weren't so evident to a person who is not familiar with a motorcycle, as I am, for instance, but for anyone knowing the Vespa, the traditional one, was absolutely able to detect the differences because it was less soft, more angle, and so on. So the differences can be very relevant. And it was interesting to know that the differences can become taken into account very often by the courts.
Okay, thank you. Anything to add?
I would just echo those comments. I think this is a good example of two ways that this is fought out in the courts in the United States. The first is you have like the shoe case that we looked at, the LA Gear case, you have the situation where an infringer may try to divide up this item into features. So I don't know if this works. It's a little hard to see. I have a laser pointer here, but I guess it won't work. But you could simply look at the base, for example, and you could say, okay, maybe the overall shape of this article and this design has alternative designs, but let's just talk about the base. And the base is small, and it's used to hold the glass, on the ground. And the narrow top of this relative to many glasses is so that there's more aroma coming out of the glass. It's more concentrated. And the sides of this that are tall, it gives a more, a better estimation of how much liquid is inside of this. And therefore, you combine all these things and it's dictated by function. I think that would be problematic, and most courts will see through that. Certainly the Federal Circuit, the Court of Second Instance, would see through that. The other aspect of this is how you define the function, and that is another battle that is often fought, which we have not talked about much in our case law. And if the function is simply to hold liquid, that's when it becomes more problematic. I would liken that to the Hupp case with the mold that we had, where the court said, well, the function of this is to hold concrete and put it in a shape, so therefore it's dictated by function. But if you define the function in more detail and with more specificity, then it becomes harder to invalidate because the functions can start to differ.
Also, if I may, in our case, we don't have to lose the knowledge that the law has to be interpreted as a whole, and what we protect is the appearance of a product, and the overall appearance of a product. So we should not disseminate the features and turn the discussion into absurd. I mean, just to say, no, it's because it needs to be like this, because to hold it, no. Okay, we have to consider the whole appearance of the product. Okay, so I fully agree with your consideration. Any different opinions? Okay, Chaos. Professor?
Thank you. It's not our opinion, it's a question. Regarding the bottom of the glass, a recent amendment of Mexican law for design approach to the European directive and includes the concept of freedom of the designer. Considering this, what are the grounds or the steps that the courts take into account for consider the freedom of the designer to make this have functionality or ornamental?
Thank you. Yes, very good question. Thank you very much. Functionality indeed is a very important aspect, which is not just taking place in terms of validity of Article 8 in the European Union, and it also have to be assessed in the scope of protection on Article 10.1 and also 10.2, which is the freedom of designer. And when we think about freedom of designer, if there are functional restraints which are in order to design an object, then the designer's freedom is constrained, which means that even smaller differences in terms of the accused product may result in different overall impression. So yes, indeed, it's very much affects the case in terms of infringement.
Yeah, and I would just add from the U.S. perspective that while we don't necessarily have freedom of the designer enshrined as the doctrine, I do think that's the other side of the coin for the existence of alternative designs. And that's a very critical part of the United States law. The case law is not fully there, but that's the first thing you always ask when there's an invalidity challenge based on functionality. You say, okay, what else is out there? And then you go and you review the other aspects with it.
Okay, thank you. We are running out of time, so let me jump into this last one. Okay? So.
Again, this apparently is just a vase, so no functionality. But maybe it's a way to handle or to move in an easier way, or maybe there is a special need to have different temperature in the different part of the ground, the terrain inside. I can hardly perceive it as creative, but theoretically it should be. Let alone, of course, new shape, originality, individual character, all these things. This is a different story, but maybe it could be also perceived as non-purely functional and then protectable.
I would say this case would depend on a lot of fact-finding, as my colleague said here, that if you find some kind of information about this design or patent documentation, it might be also a concrete tube which is in the ground. We don't know. It's a tool to hold a vase, so from the pictures. So if you can find, for example, documentation, even not from the same prior art, saying that it's holding a plant, but it's a tube, I don't know, for construction purposes, that might be also used in order to invalidate based on functionality, because they're in the European regulation and the Locarno classification does not define the scope of protection and also validity.
I would just say very quickly, if the function is defined as holding a flower, then perhaps this is dictated by function. If the function is defined as holding a flower such that when you water the flower, the water does not drip down the side of the pot and make a mess, then you go to alternatives. You could make the lips smaller, for example, and then you might have a design that is not dictated by function.
Great. Thank you very much. Any last question from the audience? Yes?
Good morning. My name is Veronica from Peru. As you well said, functionality is related to overall appearance and invalidates design patent, right? But what happens when Nike develops their last Nike Vaporfly 4, which improve running ease and speed? So, as a shoe, it would be design patent, and also would be allowed in running competitions. But if you take in consideration allowing to run faster, it would be an unfair type of competition in a running type. So do you think the functionality should be or could be modified?
I believe you are talking about the Berlin Marathon, not Berlin, I think, where the 2 hours, less than 2 hours, was ran and with the Nike shoe. Well, probably it's the fastest shoe because it's on the fastest person in Earth. So I don't know if that's true in terms of functionality, and I believe that it does have design elements, so appearance, and not just dictated by the function, those shoes. I would say so.
Okay, let's, any closing remarks? No? Okay, thank you. So, well, although we share the, yeah, but, well, we are out of time. I think you can have the opportunity afterwards over there. So thank you. I'm really sorry that we must respect the time. Okay, so well, although we share the fundamentals in both sides, I think there are some relevant differences when approaching both validity and the scope of protection. So the challenge is to work together in designing the worldwide protection and enforcement in design, because especially maybe when protecting partial designs, this is a very relevant issue. And after Dr. Ram, we have a kind of an earthquake with the multiplicity of forms theory in Europe and versus US, so we have to take all this into account, but we will do it. I'm sure we will be able to overcome the situation and to plan a global protection strategy, okay, for our clients. So thank you very much. Look and functionality. Functionality of this panel has been more than correct. Thank you very much. And we look forward to see all of you tonight with a nice pisco in our hands. Although we are those guys handling these 1% issues, we are cool and nice, and we will be very grateful to speak with you tonight with this pisco in our hands. Thank you very much.